We've received, a ton of email from people asking us why Andrew Shervill still has a job as an assistant attorney general in your office. And free speech is critical, but he appears to be targeting a college student. I know you've said that this guy's views don't reflect your views or those of your office, but why is he still employed?
Well, for a number of reasons. Here in America, we have this thing called the First Amendment, which allows people to express what they think and engage in political and social speech. And more on point, the Supreme Court, both the United States Supreme Court in 1995 in a case called the U.S. versus Treasury employees, said that civil service employees in the federal system and by extension in the state system have free First Amendment rights outside of the work as long as it doesn't impact their performance at their job. And Mr. Shervill is sort of a frontline grunt assistant prosecutor in my office. He does satisfactory work, and off hours he's free to engage under both our civil service rules, Michigan Supreme Court rulings, and the United States Supreme Court rule. Interestingly enough, by Justice Stevens wrote the opinion to engage in free speech.
But aren't you empowered by the state civil service rules to discipline him for conduct unbecoming a state employee? Do you think his actions are unbecoming of a state employee?
Well, his actions are offensive. But, conduct unbecoming is one of those empty vessel statements. What it means has never really been fleshed out.
Do you think this is unbecoming?
It's certainly, it's unbecoming of civil discourse. It's unbecoming of common courtesy. And, quite frankly, I feel embarrassed for Mr. Armstrong, that he has this unwanted attention. But again, Anderson, this is speech put on a blog. Now, if there's conduct that's verified, for instance, if a personal protection order was sought by Mr. Armstrong and granted in the Michigan Civil Service sort of disciplinary code, we could start looking at things in terms of perhaps sending to an employee assistance program.
So if there was a restraining order or something filed, or there was a lawsuit by Mr. Armstrong against Mr. Shervill, you might look at this differently, or that might change your ability to do something.
Absolutely. There's a spectrum between pure speech and actual physical actions. Now clearly, if he was stalking him and violating the criminal law, action could be taken against him.
But I was reading this Supreme Court case, and the court said, and I quote, "Government agencies are charged by law with doing particular tasks. Agencies hire employees to help do those tasks as effectively and efficiently as possible. When someone who is paid a salary so that she will contribute to an agency's effective operation begins to do or say things that detract from the agency's effective operation, the government employer must have some power to restrain her." Isn't Mr. Shervill detracting from your agency's effective operation? Why would any gay person feel confident that he or she would be represented by this man as an attorney? Or, frankly, they would start to have perhaps doubt about your office's ability to do that.
Well, I think that's quite a stretch. First and foremost, Mr. Shervill, his job is he helps preserve state criminal convictions when they're challenged in federal court. He does that well, from 8:30 to 5, very well. Him blogging, it's not impacting the mission of the office. You've
made internet safety one of the main initiatives of your department. You've done public service announcements about it. We found this pamphlet that the state of Michigan issues that they define a cyberbully as someone who uses technology to harass, embarrass, intimidate, or stalk someone else. And they say the type of content a cyberbully may send includes the following: vulgar and argumentative message, cruel, offensive, and insulting remarks. Under that definition, is Andrew Shervill a cyberbully?
Well, that's a pamphlet by a different agency, and I'm glad you brought. We've educated 500,000 kids on how to protect themselves from predators and also bullies on the internet. Now, that being said, there isn't a crime of cyberbullying in Michigan law. And the reality is...
But I'm not asking you whether it's a crime or not. I know in Michigan there is no cyberbullying law yet, but do you think he is a cyberbully?
He's clearly a bully. Absolutely. And is he using the internet to be a bully? Yes. But is that protected under the First Amendment of the United States Constitution? Yes.
Jeffrey Toobin last night in this program, a CNN legal analyst, said that this is more about you than about Sherville. And he said that Sherville is a political ally of yours who worked on your campaign, and that you campaigned on family values and weren't very supportive of gay rights, and to fire him would be politically difficult for you, and that plays a part in this story. I wanted you to be able to respond to that.
Well, Mr. Toobin reminds me of the old joke. I'm not a lawyer, but I play one on TV. Because he clearly didn't read any of the Supreme Court case that I cited for it.
He's a former federal prosecutor, but you're saying politics has nothing to do with it.
That doesn't mean anything, Anderson. He's not in the ring every day practicing law. He's spending time on CNN. And it's a pretty good gig. I wish I had it. But the reality is, I'm out of office in 3 months. I have a duty to defend the Michigan Constitution. I have a duty to defend the Michigan Civil Service rules, even at those times when I don't like it. I mean, part of my job as Attorney General is to stand up and defend the First Amendment, even when that protects offensive people and people who are saying things I don't like.
Attorney General Mike Cox, I appreciate you being on. Thank you.
Thank you, Anderson.